Good afternoon, everyone. My name is Richard, and on behalf of the entire at the Maine State Chamber, it is my pleasure to welcome you to our webinar concerning data privacy, the latest in our webinar series. Thank you so much for joining. We would like to start by thanking our sponsors. Our supporting sponsors this morning are Hannaford Supermarkets and the Maine Bankers Association. And our 2024 webinar series sponsors are AARP, Central Maine Power, Northeast Delta Dental, Kennebec Savings Bank, and Sun Life Insurance. And there are just a few things we'd like to share with you about today's session. The first is this meeting is being recorded, and we will make the recording available to you on our website in the next few days. We brought you into the call with your audio muted, and you do have the ability to unmute yourself if needed. The format for today will be please submit questions into the chat panel addressed to everyone, and time permitting, we will answer them at the end of the session. And we will use the chat function to share useful links and other materials in the process. Please just use the same Zoom link to reconnect. Sometimes you may need to restart programs in your computer, but the link should be working. It is now my pleasure to introduce the President and CEO of the Maine State Chamber of Commerce, Patrick Woodcock. Good afternoon, Patrick.
Well, good afternoon, and thank you, Richard. Do appreciate all of those joining us today, and moreover to our sponsors and our participants today. For those who followed this issue closely, the Judiciary Committee has typically been meeting on Monday afternoon, but really those discussions are going to have far-reaching consequences for the Maine business community and for the state, either those who are concerned about privacy, but moreover how they're utilizing their current practices in obtaining consumer data and how that is utilized. Very pleased with the collection of speakers today. We wanted to press upon our membership that, first of all, this issue, while far-reaching, is not happening in a public policy vacuum. There are certainly other states that have taken this initiative on, and understanding that context is important. Furthermore, this will not be an academic exercise for Maine businesses. This is going to have tangible consequences for everybody from loyalty programs to also those engaged in biometrics, and also how we collect and store information. We did want to begin. I wanted to say, first of all, thank you to Senator Heim, who's joining us today. We would typically begin with our legislator, but we wanted to make sure that the entire framework of privacy is explained first, and we're very pleased to have Jordan Crenshaw, who is the Senior Vice President from the U.S. Chamber of Commerce's Technology and Engagement Working Center, to give an overlook of data privacy across the country. We will then move to Senator Keim to explain legislation that she has put forward. She represents, for those who have not had the opportunity, she is in her fourth term serving Oxford and Franklin counties. We'll then turn to talking about the importance of personal identifiers with Josh Stearman, who is Director of Government Affairs for the Maine Bankers Association, and finally Curtis Picard of the Maine Retail Association. We'll be discussing data privacy on loyalty and reward programs. Again, I want to thank all of you. I do think this should be getting more attention from the Maine media, and is one of the most consequential issues for the Maine Chamber this session. With that, I wanted to turn to Jordan, and again, thank him for joining on behalf of the Maine State Chamber of Commerce. Jordan?
Patrick, thank you for the kind introduction, and happy to and glad to join you all today. Unfortunately, the Patriots were not in the Super Bowl, so I was not up too late last night watching. So I wanted to chat a little bit today about and provide context for what is happening outside of Maine in terms of data privacy, both federally speaking, but also on the state side. The U.S. Chamber of Commerce, in fact, supports national data privacy legislation that protects all Americans equally. It's critically important that we not have a patchwork of state laws that make it difficult for businesses to comply across state lines, but also makes it easier for consumers to know what their rights are from state to state. And I think one of the key issues there and the important pieces there to know about the patchwork issue when it comes to the federal legislative side is the immense cost that could come from a patchwork. For example, if businesses are required to comply with potentially conflicting state laws, it can put them at a disadvantage, particularly if they're a smaller business, given that data is essentially what is used by industry these days to make core business decisions. There was a report that came from ITI that estimated that a state patchwork of privacy laws would actually cost the economy $1 trillion over 10 years. And with 200 billion of that being borne disproportionately by small businesses. We actually did our own homework at the U.S. Chamber of Commerce and found that small businesses that actually do not have access to data, or those that are concerned about overly restrictive data regimes, could actually have their business operations harmed. In fact, 75% of small businesses nationwide say that they believe that data and tech platforms help them compete. Another 75% said that reducing their ability to use data and things like targeted advertising would harm their operations. And a majority of small businesses nationwide have said that they are worried that complying with out-of-state privacy laws that are different would actually increase litigation and compliance costs for them, which puts them at a unique disadvantage. That said, I'll talk a little bit about some models out there that are competing in terms of where states are from a privacy perspective. I bring up the federal first, the Data Privacy and Protection Act model, because this is a model that we are seeing in states like New York, Massachusetts, and Illinois. That is based on a bill that was introduced in Congress last year, which is the American Data Privacy and Protection Act, that was put forward by the outgoing chair of the House Energy and Commerce Committee, Cathy McMorris Rodgers, and the ranking member of the House Energy and Commerce Committee, Frank Pallone. This bill, for a variety of reasons, has some concerning elements to it. First, from a federal standpoint, we view it as having weak preemption, which would not help with a patchwork. That's not really relevant on the state side, but just a note for folks who were kind of following along what's happening in DC. The other problematic part of the American Data Privacy and Protection Act is it actually has a data minimization standard that would enable companies to only use what is strictly necessary for the operations of their business, which would put them at a unique disadvantage, particularly with the definition of sensitive data at play. That's a concern, just one, because we're concerned about the impact and innovation and being able to provide new products and services to consumers, but also the American Data Privacy and Protection Act model would also require businesses to run impact assessments on artificial intelligence and look at things like disparate impact to determine if artificial intelligence is disproportionately harming certain communities. The inherent contradiction is if things like race and gender data are considered sensitive and not available for collection, how will businesses be able to both comply with the impact assessment provision to determine whether or not protected classes are harmed by things like AI? So that's a concern that we've seen there as well. The other concerning piece for the Data Privacy and Protection Act is its enforcement mechanism, which would be enforced by a private right of action, which is the ability of companies to be sued by private citizens as opposed to a expert agency like the FTC or state attorneys general. And I think one of the main concerns about that is, in particular, we've seen small businesses be the target of frivolous lawsuits that generate class action settlements, harm the small business for technical violations that do not cause harm, but enrich the trial bar. And I think that's a concern we've seen. We've seen this with the Telephone Consumer Protection Act. We've seen this with the biometric privacy laws in Illinois. And that's a concern for why we have problems potentially with this American Data Privacy and Protection Act model that came out of Congress. And other problems as well with private rights of action. If we are trying to get to more uniformity, the problem with PRAs, or the acronym for that, is that it actually could lead to a patchwork of district court decisions in addition to a patchwork of the underlying regulations. So those interpretations of what those states mean could be susceptible to different court interpretations, which just compounds the patchwork. So that's the Data Privacy and Protection Act model that we've seen out there. It does have some similar protections that we've seen in other states. And I'll compare that Data Privacy and Protection Act model to another model that has emerged in the states, and that is the consensus privacy approach. It is a model that has passed in 14 states across the country. It has passed in blue, red, purple states fairly unanimously. The first time that this bill was passed, it was passed in Virginia. It has seen some form of change and amendments and add-ons in states like Colorado and Texas, and also in Connecticut. And what this bill does is it actually provides consumers with the right to access, correct, delete personal information, and it gives them the right to have portability with personal information. And it then provides consumers with the ability to have opt-in consent for the processing of sensitive data. So, things like racial data, gender data, those types of things that could potentially cause harm down the road that's been foreseeable by these state legislatures. That opt-in is solely for sensitive data. That's uniform across all of these states that have passed this consensus privacy approach. There are opt-outs in these bills as well, or these laws that have passed. Generally speaking, there has been an opt-out for targeted advertising, an opt-out for the sale of data, and also an opt-out mechanism for what's known as profiling, and that's the use of automated decision-making in select legally significant areas like insurance, housing, employment, basic needs and services. So that's generally, in a nutshell, the consensus approach in terms of the requirements on industry, the obligations on industry. In terms of enforcement, enforcement has across the board been given to the state attorney general, and has explicitly in most states stated there is no private right of action. None of them explicitly provide for a private right of action. And so I think those are really interesting notes just to compare where we currently are with the consensus state approach that's been adopted by blue, red, and purple states. And if you actually want to see an op-ed I put together on this, it's actually in Real Clear Policy, and we can share that after this. But there are some other outlier states I do want to make people aware of outside of the Data Privacy and Protection Act model, as well as the consensus state approach model. California was the first state to pass privacy legislation. It provides many of those same consumer rights that we've seen in the consensus state approach, but it does give broad rulemaking authority to the state's privacy agency. That's a concern as well because of the fact that this could further compound a state patchwork if we do see multiple different rules that are conflicting with the other state laws that are out there. There's California. It's kind of on its own. Washington State has actually passed privacy legislation for health data. It has a very broad definition of what's considered consumer health data, and that is subject to opt-in. That is enforceable by a private right of action in the state's consumer protection statute. That bill goes into effect in about a month, and we'll begin to see the impact of that law very shortly. Also, a couple other outlier states I just want to make people aware of as well. Michigan, for example, is looking at a bill that would provide an opt-in approach for all personal data. That's in contrast to the consensus state approach, and also would enable prohibitions on the processing and sales of data for those between 13 and 18. And that bill also would enable class action lawsuits in a private right of action. But generally speaking, the majority of states are either looking at bills that look like the consensus state approach that I mentioned. A few are looking at the Data Privacy and Protection Act model that is based on the federal legislation that came out from last year. And finally, we are seeing some outlier bills, whether or not it be the Washington My Health, My Data Act, or the Michigan model. But I think once again, just goes to show everyone it's important to understand how these bills all work together, or if they don't work together. And once again, reemphasizing from the U.S. Chamber position, the importance of federal legislation that provides one single framework for the country. So I'll be happy to answer any questions y'all have at the question and answer period, but really appreciate the opportunity to join you all today.
Thank you, Jordan. Do appreciate that overview and the intersection of the state discussions with federal, with overarching federal legislation. I did want to turn to Senator Keim now, who's been at the forefront of a lot of these discussions. We're so thankful for her engagement on the topic and joining us today. Senator Keim.
Thank you. It's good to be with you all. As you know, I am in the Senate and I represent the most beautiful area of our state, which is the Western Maine Mountain region. And I'm in my last term in office and just really tackling a massive topic here in my last term. Recently, AI experts have said that in another 5 years, we will see upright artificial beings who are going to talk to us and who are going to have better memories than we do and will know everything about us individually. This can happen because every bit of information about us is being collected. Where we shop, where we drive, go to medical appointments, who we visit, call, or text, which people might be in our tightest circle, what we say to them, what we might be passionate about, everything we've ever searched on the internet. It's all known and it's saved somewhere in the form of ones and zeros. And the master of all programs, AI, will soon have capacity, if it does not already, to pull all that captured information into one cohesive owner's manual, if you like, on each one of us. And this can happen because laws are hopelessly behind technology advancements. At the age of each of us in the meeting today, all of our information has already been captured. And even now, there isn't much in the way of laws or regulations that are stopping it. So there's nothing really for Maine. And our biometric data, our retina scans, our fingerprints, our voice prints, they can never be replaced. They can't be replicated, but they can be replicated. So this is why data privacy legislation matters. It matters to all of us. But for you and I, since most of it's already been collected, I guess you could say the gate's been left open and the horse is already out of the barn because there haven't been any protections in place. So when we look at this legislation and the idea that we need to start protecting our privacy, it's really looking to protect our grandchildren. Maybe if some of you have children that are young enough, it might help them in some way. But we all agree that we should have control over our personal information and that we should have a right to privacy. It's just something that we hadn't really expected. As technology advances, you just don't expect what's going to come down the line. And now all of a sudden, we're realizing the vast amount of information that is collected and stored on us and the danger that it is to us. So, because of all that, this session I submitted actually for the second time the same law that California implemented that was mentioned. And I was so glad that I didn't have to give the overview on privacy because I struggled to keep up with understanding my own bill. And the California law is one of the most protective in the country, but as I've learned kind of diving into this, it's also overly complex. And it's not one that any other state has tried to emulate or implement. And the reason why is because it's just so darn messy. You would think that the tech capital of the world could get it better than that. So I put in that bill again, and I was approached by members of a business coalition, and they asked me to submit a different bill, and I think it was referred to as the consensus privacy approach. But in the State House, we're kind of referring to it as the Connecticut framework. And I did agree to put in that bill because I understand the need to have interoperability for businesses. Many of the businesses here in Maine do business in other states. Obviously, businesses from around the world, right? And big tech is doing business here with Maine people. And, Maine people, they want privacy protection, but they also want their businesses to survive and be able to serve their needs and wants. So, what we're looking for is a world where both can happen. And that's really the heart of the work that we're undertaking right now. We're diving deeply into legal language. If anyone has ever watched a tedious session of the legislature, it doesn't get any worse than what's been happening in the Judiciary Committee. But we are trying to understand the practical outcome of the words as we throw so many words around, and we try to craft a broad-based privacy policy for Maine people. And words matter, right? So as we kind of fool around with the words and pull, ideas from different bills in different states, we've been sort of putting together a hodgepodge. It's been lovingly referred to as the Frankenstein bill that we may be creating. I'm sure Curtis will have something to say about that. But hopefully, we're going to come to consensus. And the goal is everyone wants a bill that's comprehensive to pass. We definitely disagree on a lot of the details of that. But if we don't come to a consensus, I think it'll be really difficult to get anything to pass because none of us are experts on this issue. We're all just, regular Maine people, who get voted into the legislature, and we know the overall need for this, but we don't understand how it could play out in real life. So the process has been very collaborative in some ways. There's been a lot of business involvement. Obviously, a lot of privacy experts who want to see certain things happen. So there's been a balance of voices, right? The people who want absolute privacy because they're not in business and they only want what they view as the very best for the consumer. And then there's the business who is coming in to say, here's, what we want. And, sorry to everyone that's listening, we also know that businesses want to have something that works for them. And their highest interest is making sure that their business is successful. And then we've got the privacy experts whose highest interest is making sure that people's privacy is protected and businesses are not their concern, very obviously. So I think, we right now, like I said, I'm not sure where we're going to end up with this. We are still working. We've got another session on Wednesday. And one thing I will say is that if you have real life experience with this, join in. It's been pretty open to whoever wants to give their opinion on this. the committee has been very interested. And so far, it's been mostly just sort of two expert voices. But when someone comes in and says, this is how it's really going to impact me, the Judiciary Committee listens because they want to hear from real people. Because again, I don't think even one of us on the committee, well, there's one on the committee that probably has some experience with, what privacy laws, how they impact their business, and what they do sort of behind the scenes. And that's really important. So I think that's all I have for an update. The AG here, the AG's office presented to us in our last meeting a hybrid approach to how we would enforce this, and that would be a combination of right to cure, which is basically a consumer would be able to send a letter to a business and say, you've sold my data or you've done something with my data that you weren't allowed to, and they have 30 days to make it right. That's a sort of a high level right to cure. And then, but the Office of the AG also suggested to have a private right of action as well. And I haven't dug into that language. I had to leave committee just as it was getting discussed. So I need to brush up on that. I am very concerned, and many legislators are really concerned about what would happen if we open up a full private right of action, because we've already seen what happens to businesses when they get kind of attacked, and only lawyers win, right? No one wins there. So that is a big issue that we're trying to kind of push back on. The problem there is that if the Office of the Attorney General, if we make it just a right to cure, the Attorney General is going to slap a really big fiscal note probably on the bill, and then that might kill it. So there's sort of some internal dialogue happening around what can we get past, what's the best thing to do, and then what's possible to do. That's kind of our questions as well right now. So I think that covers everything. And if anyone has, something to add, or maybe bring up something that I should have mentioned but didn't, please feel free.
Well, thank you, Senator. It's so interesting to hear about your own legislative journey as an individual and being at the forefront in Maine's privacy debate. And it has been a robust one, and we certainly appreciate the effort on balancing so many interests. I would love to ask some questions right now. I did want to save those for the end if you're able to stay with us.
Sure.
And turn to Josh, who's going to give an assessment of some of the privacy issues as it relates to security. Josh.
Thank you, Patrick. Thank you, Ashley. It's a pleasure being here. I'm Josh Stearman with Maine Bankers Association. So like Senator Kimes and Jordan from the chamber said, banks, we understand and really embrace this need for privacy. The challenge is that this is such a complicated and technical issue that the details really matter. And a good bill could be a win for privacy and workable for businesses and step forward for regular people. But the wrong bill could really degrade all of those at the same time. So the details are really important. Our business is really based on trust. We're very highly regulated. And so trust and privacy is something that we understand and have embraced for decades. Our bottom line is that we want to see a bill come out that protects consumers with modern tools. Generations ago, security meant big steel bank vaults, but today, investment in security really means cybersecurity, that computer infrastructure protecting online data. So one of the best tools today that's used to protect your data online, especially your bank account, is called biometrics. That's things like a fingerprint scan or an eye scan to get into your bank account on a mobile device, or it could be the voice signature that you use when the bank tries to identify you over the phone. Those are all things that customers opt into, but anecdotally, local banks in Maine are telling us that 80 to 90% of their customers are choosing to use those because they know it's more secure. Both customers and also security experts will consistently tell you that use of biometrics as a way to do multi-factor authentication, so not just passwords, but something more, it's infinitely more secure. So these are modern tools that people are demanding and are much safer. The issue is if the wrong bill gets passed, any business that's touching that kind of data at all, it could be a bottomless pit of legal liability if something was to happen. And obviously bad actors need to be held accountable. But if we have a bill that treads new ground and is going into uncharted legal territory, it's going to be really challenging to understand that landscape. And there's a very strong chance that some financial institutions may back away from using biometric identifiers. So that leaves with a bottom line of a bad bill is going to leave Maine consumers less safe because they will no longer have access to these modern cybersecurity tools that we all know are much safer than passwords alone. We're also concerned about Maine being, as earlier speakers mentioned, if one small state does something differently than 49 other states, that presents a significant risk that certain products will be unavailable, certain businesses will not be able to quantify the risk and potential liability. So again, that just leaves Maine customers with less protection and less choice when they're out in the marketplace. And we think that's a bad thing. Maine customers ought to have access to choice like you have anywhere else in the country, and Maine customers ought to have access to cutting edge security. So we've been trying to advocate in Augusta and working with legislators and our business partners for a bill that follows a consensus model. These are things that are tested on the ground and in the courts, and also doesn't make Maine an outlier that's going to leave people out in the cold. So I'm happy to answer any questions, but the bottom line is that we're afraid that a bill making Maine an outlier is simply going to leave regular people less safe without access to the modern 21st century security.
Well, thank you, Josh. I think that's a very specific but tangible issue that a lot of consumers and businesses can understand. I had some follow-up questions, but going to wait to the end here. We're going to move to Curtis Picard to discuss the implications potentially on loyalty and rewards programs. Curtis.
Thank you, Patrick, and thank you to the Maine State Chamber of Commerce and also for Senator Keim for participating today and organizing this webinar. I think this is, without question, probably the single most important issue of this legislative session. I've been around a while now. I've been through some really big public policy debates over the years. I've been through tax reform. I've been through workers' comp reform, paid family leave last year, even things like EPR, and we're all continuing to talk about things like PFAS. Definitely some very meaty issues. But I can't recall ever a policy area where we've spent, I think, between 8 to 10 significant work sessions now on this topic. And each work session is taking anywhere from 2 to 5 hours, and it's a big chunk of time. The upside of that is that I've learned a lot, as I think everybody has on this webinar that's been presenting. We've learned a lot about consumer privacy and comprehensive privacy and understanding what's happening in other states. So we've been actively involved throughout this whole process. We were involved last year. We've been involved through all the work sessions through the fall. And I have to give the Judiciary Committee credit because they are certainly taking the time to look at these issues from every single angle. But Senator Keim is right. I feel like the way that the committee has been going through this, comparing the two bills, LD 1973 and 1977 side by side, is leading to a bit of a Frankenstein type of approach right now. And I think the policymakers have said on mic multiple times that until we all see an updated draft, it's very difficult for any of us, even with all the time we've spent looking at these issues, to understand where it is currently and what the impacts are going to be. So if I can leave you with one thought from what I'm going to say today, is it's very important to understand how these different pieces interact with each other. So addressing things and fixing things like the definition of sensitive personal information has an impact on how data minimization is going to work. And if you don't get those two things right, they're going to end up being out of whack, and it could throw the whole bill off. Retailers, of course, are very consumer facing. And so we're very much a face of privacy. And I'll disagree a little bit with Senator Keim and say for the retail industry, we care very much about the consumer experience. So it's not just about the needs of the business. For retailers, it's maintaining a strong relationship with our consumers. We want people to come back and buy again. We want loyal customers. So I'll start first with loyalty programs, because that's one of the areas I wanted to make sure got addressed. You're all probably familiar with loyalty programs. And if you're as old as I am, you remember the punch cards you used to get at your local coffee shop, where you come in 10 times, get your card punched, and then you get a free coffee. That's a loyalty program. Nowadays, they've gotten a lot more sophisticated and technology based. So whether you're talking about Hannaford rewards or your Irving rewards that saves you 10 cents a gallon, loyalty programs are very popular with consumers. The average consumer has 9 to 10 different loyalty programs at play at any one time. I'm certainly one of those people. I mentioned the two that I already participate in, but I also have one for I use my Target Red card when I go to Target, and I have one for Panera Bread when I have lunch there, etc. And loyalty programs, by their very nature, are opt-in. Consumers are choosing to participate in them. So that's part of the piece that's considered opt-in. And some of the other speakers have talked about the differences between opt-in and opt-out. And that's where it's also very important to understand how this bill interacts with each other, because that ultimately depends what processes end up being opting in versus opting out. And right now, the status of these bills is it's very confusing to understand what's going to end up being opting in versus opting out. But regardless, especially from a retail point of view, one of the terms that we use frequently in the industry is frictionless. And Josh kind of referred to this as well. You know, the banks are using a lot of facial recognition now, thumbprint when you log into your bank account. But all of that goes back to trying to provide a frictionless experience for your consumers. Retailers have long strived to do that. We continue to do that. But part of that happens is through the interactions we have with you, either in person or through websites, through e-commerce, that type of thing. And so we're very concerned about how this bill is going to play out and how it's going to impact a frictionless experience. And is it going to lead potentially to consumer fatigue and having to either opt in or opt out of multiple processes along different points in time? So that's a very important area that we're talking about. Loyalty programs, for the most part, are pretty straightforward. You get a certain percentage off or a discount or something free. Where we care about the details in this bill and how it interacts, and you've probably seen this with some of the loyalty programs, is you could be participating in a retailer or a business with a loyalty program that also gets you a benefit somewhere else. So, you know, if you say hypothetically get 100 gallons of gas, you'll get a free ticket to a concert or an event. So at that point, there is some consumer information that has to transfer from the loyalty program that you've opted in with to the participating partner that's part of that promotion. And so that's why we care so much about the details of how data gets transferred. And we don't want to hamstring things that consumers want and expect. And I think that's the other important message here as well, which is consumers in Maine shouldn't ultimately end up having with a different consumer experience than they're going to expect and receive in other states. And that's why we think it's so important that what's known as the Connecticut model, or you can refer to it more appropriately as the New England model at this point, is really turning into the de facto standard across the country. 13 to 15 states have essentially adopted this framework. New Hampshire and New Jersey are the two most recent states to come on board. And so it's very important that Maine not end up being an outlier for our 1.3 million residents. Not only is that going to lead to a significantly different experience for consumers, it's also going to put the businesses at a significant disadvantage for cost, complexity, and compliance if Maine ends up doing something completely different than other states. So, as we've told Senator Keim, the Judiciary Committee, and all those other policymakers, we are very hopeful that we can reach a place where we can publicly support comprehensive privacy legislation in Maine, but it needs to be in line with other states. Where it stands right now is I'm not sure we're there yet. I really do appreciate Senator Keim. We've had a lot of robust conversations with her. I understand where she's coming from, and I think she also understands where we're coming from as retailers. And I also think there's benefit in really trying to understand ultimately what are you trying to fix? What are you trying to regulate here that isn't already being regulated through policies that have been enacted in other states? So we'll continue to work with the Judiciary Committee. I'm very happy that the chamber is raising this issue now, because as it goes through this process, we're definitely going to need people's voices at the table, talking with policymakers once this bill amendment comes out, and we can fully understand what they're proposing and what its impacts are going to be on both Maine businesses and Maine people.
Well, thank you, Curtis. And please provide comments and questions in the chat. I'll do my best to manage that. To get us started, maybe we could drill into the specifics. I know there is not a redraft that's been provided thus far, but Curtis, we've talked about private right of action. Could you drill in, what are the areas that there could be some key departures from the framework that are on the table at the Judiciary Committee now?
Yeah, thanks, Patrick. I appreciate that. And I referred to them a little bit, but as I said, to me, two of the key pieces are the sensitive personal information definition and the data minimization part. And those two interact with each other very, very closely. So however you ultimately define what is considered sensitive personal information, and by that very nature, anything sensitive is automatically going to be opt-in. The bigger that definition gets, that means the more things people are going to have to opt in for. And then data minimization essentially is the message to business is minimize the data you need to collect from consumers and people to just do what you need to do. But from the business point of view, you also don't want to be hamstrung with what consumers expect you to do. And so a good example that one of our retailers has used is under the current data minimization definition is it refers to things being so narrowly focused that we might be hard pressed to send a consumer a follow-up survey after they make a purchase with us. Now, consumers generally expect that type of feedback, and the business wants that type of feedback to try to improve what they're doing as well. So it's important to understand those different areas and how they interact overall. And then the other important area, which I kind of brushed over, I should have talked about a little bit more deeply, is targeted advertising. Retailers obviously do a lot of targeted advertising, and I understand how sometimes it can make people feel uncomfortable whenever you even say the term targeted advertising. But the idea is we want to make sure we're marketing the products that consumers want and that the business they want to hear from in an appropriate way and not a random way. Gone are the days where you're just doing a full page newspaper ad or throwing up a TV ad during drive time or a radio ad during drive time, hoping you hit your market. The point of targeted advertising is to really be able to hit your market in an appropriate way. But I understand some of the concerns with it as well when you're talking about social media and some of the things that happen in that regards. And that's where I think a lot of these things need to be focused on and discussed.
Well, thank you for that, Curtis. Seeing a question from Aaron Piper from Wex. I'll read it aloud for Senator Keim. How do you think about the potential unintended consequences that a private right of action would have for services and products being offered in Maine? Gives an example, the Illinois Nest stopped offering products in the marketplace because of their BIPA law. There's a fear that third-party vendors and other companies outside of Maine will pull out of the market because the economy is not big enough for them to risk exposing them to that private right of action. Senator Keim, your response?
Yeah, I I'm really opposed to a private right of action because I think that it will cause businesses to pull out of Maine, and and then I don't know what would happen to Maine businesses that kind of got caught up in some sort of private right of action that might be part of a bigger push. It's all a possibility. I don't know right now if that's what the committee will decide on. It's what the office of the AG is pushing for really hard. And there's definitely some people pushing back, but all those things are what we're considering when we talk about this. And then if there is a private right of action, hopefully and some people vote for that. Hopefully it's very limited.
Just as a follow-up, talking about the framework and, whether it's enhancing that framework or adding other components, and whether that cobbles into a Frankenstein, we'll see. But really, Senator, from when you look at the framework from Connecticut, what do you see as the major limitations for you to fully endorse that structure?
The structure I endorse and like. I think that really what we're doing is trying to make sure that we use that structure, and then because of the interoperability of it, but then make it as strong as we can in that framework. So the last meeting that we had, there was a change about the sensitive data, and right now you have to so in the Connecticut framework, a person would have to opt in to having their sensitive data used. But recently, the committee switched that so that sensitive data would only be utilized by a company if they used it in a manner that was strictly necessary to the process or the service or whatever that the consumer had asked for. So it's a very limiting definition. So the consumer doesn't actually give permission or not about using their personal data or their sensitive data. It's more a matter of just saying, well, if you use it, the only way you can use it is with whatever is absolutely strictly necessary. So that's, from what I've been told, a real problem for businesses, and I understand that there is that concern there. So, so much of this is being worked out sort of minute by minute, and sometimes I'm afraid not even to show up at committee because I don't know what's going to happen when I'm not there. Because words just start flying, and who knows which one is going to stick.
Does seem, and going back to Jordan, that there is a federal void here, and I wonder, irrespective of the balance of power in Congress and who's in control of the White House, I wonder if there is kind of a critical mass of support for federal legislation, and really what kind of time frame you think that the Congress could consider some federal legislation.
So I think there is a critical mass to get something done. The problem is, is the devil's in the details in terms of how that bill is structured. And, really the two major issues that are holding up federal privacy legislation right now are the question of preemption and private right of action. And when it comes to private right of action, and I can provide a little bit more information for you all. Actually, it's a report by our Institute for Legal Reform called Ill-Suited, and I'll put it in the chat, and it really talks about the problems with PRA and legislation. The problem is initially, folks on the activist side want to see a strict liability standard. If a technical violation has occurred, they'd like to see private right of action even be used for that. When it comes to the compromise language that was in the American Data Privacy and Protection Act, that was still problematic because of the fact that you could still have attorneys' fees incentivizing going to plaintiffs' attorneys that would incentivize lawsuits. You would also have a very broad compensatory damages requirement. That's very vague. And when you start looking at the ADPPA's vague standards on things like data minimization, and then its litany of other requirements, the concern is, even if companies are doing the right thing, that there is still an incentive by the trial bar to go out, sue, hope companies don't want to expend resources to defend, and will settle in lawsuits and settlements. So I think that's a concern that we've seen considered on the federal side, but it is going to take solving those issues to really get to an end game for federal privacy legislation.
And just as for our Maine delegation, has there been engagement from our senators and House members? And I know this would be on the U.S. Senate Judiciary Committee of Jurisdiction, but any other roles for energy and commerce and the other committees of jurisdiction?
Energy and Commerce is the one leading on the House side. This will also inevitably be on the Senate Commerce side of the House as well. We've seen a lot of conversation around artificial intelligence being a potential impetus on the Senate side to do something as well on the privacy side. But at this point, all roads are going to have to go through ENC to get something done. If and when this happens.
Josh, I wanted to drill down a little bit on the biometrics and what kind of language you're most paying attention to. It sounds as though, depending on the exact details, how biometrics might be affected. Are you looking for a specific exemption, and where do you see the committee going on this topic?
Where are they going? I'm not sure. I'm foolish enough to try and make predictions, but we are looking for a specific exemption on this issue, and that's because banks are so heavily regulated already, and there are federal data privacy rules, not similar to this, but a little bit different about how banks deal with customer data and what protections are around that. So since the 90s, the banks have been prohibited from sharing or even selling any customer data. We can't sell customer data at all. And banks are not enforced through litigation, but actually through examinations, which is a very thorough, rigorous, ongoing compliance review. So, obviously can't speak for other industries, but banks were already regulated very heavily on this stuff, and have a track record of understanding, trust, investing in technology to protect it.
Josh, is it specific to biometrics or privacy, the privacy statute in general that you're seeking?
It's more generally towards customer data and what kind of protections are around customer data. And again, the devil's going to be in the details, because there are already a lot of federal definitions for what data falls under these laws and what's protected. So hopefully we use existing federal definitions and go where other states have gone. Because if we try and parse that and be too cute, frankly, with some of the language, we're going to wind up back in litigation defining what some of these terms mean, or having state bureaucracy have to make these decisions, which is going to be a long and contentious process because of the seriousness of the issue.
Thank you for that. Senator Keim, I wanted to drill down on kind of your expectations that we have had it alluded a couple times that there may be an additional draft. What's your sort of expectation for the next steps on the committee work? And I did appreciate your sentiment of looking at a consensus on something so complicated, but kind of timing for the committee and legislative next steps, and any assessment on your end?
Oh, if you've been with us all of those long hours, you would know we just don't have an answer to that. But hopefully, the committee was going to meet today and talk about privacy, and and they changed that to Wednesday, and I don't know why, but I could guess that they changed that, at least in part because they did kind of an about face on a big issue of the bill in the last meeting, and they need some time to think through what are the implications of that. So I think we'll have a better idea tomorrow after we get through another work session. I can't imagine that we would have more than two more. For sure, the committee's going to need to look at the language that comes out. It was, they've been taking straw polls on each and every topic and, getting an idea, if there's consensus on these. So they might go back and look at all the areas of consensus and then try to hammer out where there wasn't consensus and, still try to come up with a unanimous bill. That will be very time consuming. I do think it's the best outcome. And in order to make it happen, we'd all have to compromise on somewhere on what we feel is most important. I don't, I would love to have, better answers on this. It's just such a complicated topic. And, we're trying to weigh all of the unintended consequences against the very intended consequence of actually, protecting privacy. So, oh, and I have to say, I didn't mean to insult businesses. I caught Curtis's little, disagreement with me there. I understand that businesses care about their consumers. If they didn't, they wouldn't be in business because they'll lose them all. So, of course, they have to be interested. We all have to be interested in protecting privacy because it matters to all of us. And, I've never worked a bill so many hours ever. I mean, this has been a huge undertaking, and hopefully we'll get there.
Yeah, Senator, it's all with respect as well. You and I have a great working relationship.
Yes, absolutely.
I did want to kind of conclude that the point was made by a few of you of just that the changes have implications on other sections, and it's hard to see the consequences without a full package. But I did want to see if anybody has suggestions. The chamber certainly provided testimony, although that was all the way back, I think in December. But I did want to ask if there's any resources or that we could disseminate to our membership that we think would allow business owners and members of the community to educate themselves on these key topics. And this is something that's pretty hard to follow, Augusta, but this one's about as challenging as any issue. And we can disseminate that to our group. But anything that comes to mind from any of the speakers?
Yeah, I can chime in because one of the moments for me was when, early on they were talking about having concerns about when data gets transferred from one entity to the other. And, when you start talking about it, you kind of get it. It's like, yeah, they shouldn't be transferring my data to whomever. But the example that one of our members used is if we don't transfer your name and address to UPS, we can't physically ship you your package that you order from us online. And that was kind of an aha moment for a lot of members on the committee to say, oh, okay, I kind of understand why some of these things happen now and they're not all nefarious. But trying to understand that and put that into legislation, that's what we talk about with the unintended consequences. So I guess my advice for the people on the Zoom is to, if you haven't already, really think about your current data processes, do some examination of them, really ask yourself some hard questions of whether or not, is there data that you're capturing that you don't really need? And what data do you really need? And where does it go? And who do you really know that you're working with?
I see, Jordan, you put a resource in the chat. Thank you for that.
Yeah, and I'll also put a link to the op-ed I put in Real Clear Policy that talks about the consensus state approach and how that should be worked into a federal bill as well too.
Well, I
think I
do
could read.
appreciate. Yeah, go ahead, Senator.
I would just reiterate that if, this is so complicated that I think a lot of businesses, all of this happens behind the scenes. They don't really know, they're just going about their business. They're like, hey, what's your name and address? What's your whatever, your credit card number. And then they just go about doing their business. So they don't really think about what's happening behind the scenes. So when I say it's great if someone knows the practical impact of what we're trying to do and how that impacts your business, it's great for them to come talk and tell us these things, like the idea of, UPS. But the honest truth is, most of us have no idea what's going on behind the scenes with data. And really, only the businesses that make data their business, right? Like big tech, those are the ones that really know, what's kind of going on behind the scenes. So the practical implications for, Maine businesses is much harder for us as lawmakers to grasp, because I think it's also hard for the business owners to grasp as well. So, but if you do, I'll just say, if you do know all of those behind the scenes details, like we've had enormous help from LLB, and a little shout out, which I think gave them a tiny bit of a black eye because someone, sort of said, oh, they're working for big tech. Well, they're not. They're just giving us good information to help us make laws. And that's what we need. So if anyone has, good information to help us make laws, that's what we need all the time.
And certainly the Maine Chamber can support you in providing that to the committee. But we so appreciate all four of our speakers, Jordan, Senator Keim, Josh, and Curtis. This is going to be an issue. I think it's going to be right through the end that we'll be seeing this legislation through the process, and would reinforce that it would be helpful to have engagement from the Maine business community. So with that, I did want to reinforce a thank you to our speakers, our sponsors, and if anybody wants any follow-up, we can certainly work to connect our speakers with the membership of the Maine State Chamber of Commerce. Thank you all, and that concludes our webinar on privacy.